Hi there, I'm James Dapperchi, and this is Coffee and a Case Note. Team, today we're going to talk about an application that is brought by a couple of plaintiffs. And those plaintiffs are a shareholder and are the director appointed by the shareholder of a number of entities in a group. Our mind's going to bend a bit around as we come to grips with these facts, but don't worry, by the end of the discussion, we'll all understand them together. Now, this group was a group of companies related to doing resources business in various different locations, various different jurisdictions, and it was a structure of some complexity. And in the group of entities, there were some entities in the group that were part of a series, as that term was defined in some of the relevant corporate documents. And there were some members of the group that were not within that series, as that word was defined in some of the relevant corporate documents. Now, one person had the role of chair, and that role of chair was sort of a supervisory role over a number of different entities and had a number of supervisory elements to it, including being able to make binding decisions for these series type entities that were part of the group. Now, the relevant thing that happened for us today was that the chair, this kind of big boss in one way of thinking of it, over the group, purported to terminate the employment of a managing director of the main company. We'll call it the main company today. So this sort of big boss, this chair, purports to terminate the employment of the managing director of the main company we're talking about today. And that is the nature of the challenge. The plaintiffs come to court today seeking an interlocutory injunction a declaration saying, hey, the chair didn't have the authority to end the employment of this managing director and so end the directorial relationship that managing director had with a number of the relevant entities. Now, if that description kind of bent your brain around the corner, don't worry about it. We're going to hold hands and we're going to talk about it and it's all going to make sense. Now, if we kind of shift back in time to about 2021 and marching on, the way this group is run is, in essence, that this chairperson is a very influential voice in relation to the conduct of the business where that chair has formal authority in respect of series companies, and in respect of businesses where the chair does not have formal authority but has firm influence and sway, the kind of non-series entities in the group. And as we've said, it is one of these non-series companies that employs our managing director. Now, what's interesting is the chair is an influential person in causing the managing director to be hired, and it is a letter from the chair that says, hey, guess what, managing director, I'm terminating you pursuant to the various powers. That is the issue we're dealing with today. What the court says is, according to the employment agreement that the managing director has entered into with the main company we're talking about today, which remember is not a series company, according to that contract, the only person who can terminate the contractual relationship, apart from the managing director, is the employer as defined, and the employer as defined is the main company. It's not the chair. And the chair does not have any specific interest, nor does the chair's chief company up here have any specific interest in the main company we're talking about today. And what that means is that the court finds in favour of the plaintiff and finds the chair did not have the power to to cause the termination of the managing director's employment. But the defendants continued to resist, and they resisted on a number of different bases. On one view, they said, hey, the chair had either actual or implied authority. They were authorised to make this call, this termination call, on behalf of the main company. The court considered the relevant law and sort of worked through the submissions that were made to the court and said, well, no, we don't think so. And said, even if that were so, then there are these relevant pieces of correspondence, these letters that are exchanged earlier in the year that make it very clear that no, we do not give the chair authority to make decisions like this. And so even if the chair used to have that authority, by the start of this year or by early 2025, when these facts are unfolding, the chair did not have power, and certainly before the chair made the August 2025 termination call, the chair did not have that authority to the extent they had it in any case. Now, there were other sort of elements, other arguments raised. One argument raised by the defendants was, hey, it was the chair's idea to hire this person. The chair caused the employment relationship to be entered into, and by causing that employment relationship to be entered into, the chair kind of took command and control and responsibility for the ongoing employment relationship and decisions in relation to the ongoing commercial relationship, including termination of that employment relationship. And the court essentially said, no. There are circumstances whereby a person may take some responsibility and may be involved in decision making or recommending a candidate or whatever it may be. That very thing of taking some responsibility and making a recommendation does not give rise to a right to terminate. Another argument was raised that was similar but not the same, but that essentially that the managing director was obliged in respect of some of their duties to report to the chair, and so the chair was responsible for sort of supervising and that sort of thing the managing director. And what the defendants suggested was, and I'm probably not doing their argument full justice by describing it that way, but was suggesting that that reporting obligation gave rise to a right to terminate the employment arrangement. As I mentioned earlier, the court was not convinced by that submission and found, on considering all of the evidence, including those arguments raised by the defendants, that the managing director was not appropriately terminated, and so the managing director, there was a declaration made that the managing director, because they were not appropriately terminated, they remained in the role. And what that meant was that their purported removal as director from some of the companies in the group was not effective either. And so by the end of the proceedings, the MD, the managing director, remained managing director, and they remained director of the relevant other entities. And so I hope that discussion of how the interrelating relationships between moderately complex corporate groups can kind of come into fruition. Hope it assisted you, and I look forward to chatting again soon over another coffee and in respect of another case note. Cheers.